Hey, class. All right, so I talked with a few of you, and you have requested some guidance on the online PowerPoint slides that I'm providing you, and so I'm finally catching up on that. I appreciate you guys giving me some grace as I prepared for this Tuesday. Let's go back to the Federal Judiciary, and I know that we've already passed it, but you know there's gonna be questions on it for the final exam, so let's go over it. Also because I really like the Federal Judiciary. It's one of the more interesting branches of government as opposed to the executive. I think I told you the executive kind of bores me a little bit, but at any rate, so the Federal Judiciary, this is a separate judiciary from the states. So as you know, we live in a federal system, or our government is a federal system, and so we have two separate types of judiciaries. We have, broadly speaking, right? One is state judiciaries, and that's the jurisdiction of the states. Every state has their own Supreme Court. Every state has their own structure with criminal courts, courts of appeal, things like that. Then we have the federal judiciary. Now, because this is the federal government class, we're going to focus on the federal judiciary. So this is Chapter 9 in Kernell in your textbook. I have to flip slides to get the next one. All right, here we go. So Article 3. Now, remember, Article 1 talked about the legislative branch. Article 2 talked about the executive. Article 3 talks about the judicial branch. And the primary focus of this is the Supreme Court, which is funny because, well, not funny, but at least interesting because the Supreme Court gets tons of cases sent to it every year. And when I say tons, I mean thousands. But they end up only selecting to hear and actually comment on about 1%. Of those. But the things they've commented on has been really, really important. So when we think about the U.S. Supreme Court, that is the highest court in the land. You can't go any further. Whatever the Supreme Court says, the U.S. Supreme Court says, that's the final decision. All right, so Article 3 refers to the federal courts, and it's the shortest article among all of the ones concerning the branches of government. The longest one is the legislative branch, and then we have the executive branch, and then we have the executive branch, and now we have the judicial. And while the executive branch was really vague, the judicial branch is just downright short, and it allows Congress a lot of leeway in deciding how the judiciary is going to unfold, basically. So, so we see here. I'm going to turn. Sorry. Shortest article. There are several hundred federal courts, but only the Supreme Court is explicitly mentioned in the Constitution's article, which means that Congress has to tell us some of the lower courts. You've heard probably district courts, U.S. appellate courts, U.S. circuit courts. Those are things that that Congress has laid out. So Congress's job, according to the Constitution, was to fill in the blanks of the structure of the federal court system. Anything lower than the Supreme Court, Congress gets the ability to kind of lay out what their jobs are, that sort of thing. Now, a lot of people were really afraid of the judicial branch of government. And this was a question for your assignment, actually, too. Why were they so afraid of it? Well, for a couple of reasons. One, this is a democratic society, all right? And it's not a democracy per se, right? Because we have representative government. We're a republic, but it's a democratic principled system, meaning that even if we're not making the decisions ourselves, we're electing those who do. But the Supreme Court, and actually all federal judges, are appointed. They are not elected. And they stay in office for life based on good behavior. But nobody really knows what it takes for a judge, a justice in the federal level to be impeached. I mean, it's happened at the state level sometimes, and we do have some instances, but good behavior, I mean, what does that really mean, good behavior for a judge? And how do you know when you see that it's bad behavior? And does bad behavior mean like personal bad behavior? Probably not. It probably means bad behavior for a judge. At any rate, many feared the power of the judicial branch, and so it took a lot of convincing for people to allow this third branch of government that was supposed to have equal authority like the other two branches had. So Federalist 78, remember the Federalist Papers were those that were printed in newspapers. They were basically op-eds where the Federalist group, Hamilton, John Jay, Madison, all wanted to convince the states to ratify the Constitution. So in this Federalist Paper, they're trying to convince the states and those that would ratify the Constitution that the judiciary is okay, that it's not going to be that much. It's not going to be that much powerful. Like, there's nothing to fear. All right. So their note was that the judiciary branch would be the weakest of all the branches because Congress had the power of the purse, meaning the power to create a budget, the power to appropriate money, and the power to coin money. That's pretty big power of money. And then the president had, or the executive had, the power of the military, right? So he or she is the commander-in-chief. And so you've got the power of the sword, the power of the purse, and what does the judiciary have? Right? I mean, nobody was really sure, and I think that's kind of why they were feared so much. I'll add one more thing too. In addition to being unsure about what the federal judiciary would do, the biggest complaint was that these are unelected officials that are going to be there for life, right? And their job is to interpret the one big governing document. And so it was, as you can imagine, it was troublesome, worrisome for people. So like I said, the framers deferred the task of determining the nature of the judiciary beyond the Supreme Court to Congress. So in 1789, that was during the first Congress, we see Congress creating the Federal Judiciary with the Judiciary Act of 1789. And this laid out things like there would be, for example, hang tight, there we go. All kinds of lower courts. Well, I say all kinds, two types. So at the time, forget this right now, we see that, of course, the Constitution laid out the U.S. Supreme Court, but what Congress did was they created lower courts, like the U.S. Circuit Court of Appeals. You'll hear that called two different things. So listen close. This branch of the federal judiciary, or this level, will be called sometimes the circuit courts and sometimes the appellate courts. It's the same thing. And then the United States District Courts. And notice how it's a triangle, and it's a triangle because there's only one Supreme Court, right? So it's a tiny triangle, right? Then the next level is a little bigger because the circuit courts have a little bit more. I want to say there's 12, but I think technically 13 maybe. We'll go over that. And then finally, the U.S. District Courts. And there are a lot of U.S. District Courts. Hang with me again. All right. So one of the first things that your book talks about is how in 1803, which was just a few years after we see Congress detailing all the powers of the judiciary, all of a sudden we see their power being expanded. And there's a really, really important term in your book that I want you to understand in this chapter called judicial review. Judicial review is not in the Constitution. Judicial review is a concept that we know the court's job is to interpret the law. That's the court's job, right? But, hold on. So their job is to interpret the law, but judicial review kind of expands it. There's an idea, or at least there was an idea, in other courts at the time and in state courts at the time, that if the judiciary saw other branches of government, be it the governor, the legislature of the state, if they saw other branches acting outside of the purview of the governing document, like the state constitution or whatever, then they could call that action null and void. So you can't do that. And that, to some people, was the job of the judiciary. During the debates, whenever we see everybody discussing, what's going to happen with this federal judiciary and how are we going to sort out this U.S. Constitution, during those debates, we also see, though, that judicial review it was kind of mentioned in letters, right? And so there's some discussion among experts about, did the founders really mean for the U.S. Supreme Court to have judicial review? Now, you may still be confused about what judicial review is, so let me tell you. It is the Supreme Court's power to strike down a law or an executive branch action that it finds unconstitutional. And while the Constitution doesn't say this, we see the court doing this all the time. The first time they did it was in this case, Marbury v. Madison. Okay, so Marbury v. Madison, we see a case goes to the Supreme Court. The case was a really menial case. It seemed like it wasn't that big of a deal. But essentially, the case Marbury v. Madison arose out of the Judiciary Act of 1789. And there was a portion of the Judiciary Act of 1789 that when the court looked at it, the Supreme Court looked at it, they said, this isn't constitutional. So they actually, that was the first time we see them really using judicial review saying, you know what, this law that Congress has passed is not a legitimate law. It's null and void because they are actually going against the Constitution. And so the very action of the court making a ruling like that created the concept, or not the concept, but it kind of established the precedent that the Supreme Court can use judicial review. Now, when we think about the Supreme Court's expansive power and people fearing the Supreme Court, I'm not sure anybody really anticipated this. And you may be asking, what's the big deal? That seems like what the Supreme Court does. Yeah, it seems that way now. But consider this. We elect the president. We elect our members of Congress. We don't elect the judiciary. And yet we have actions taken by elected officials whose actions are being nullified by another group of people that we don't elect. So if you're looking from a principle, from the democratic, if you're looking from an angle of, is this a democratic institution, you might say, no, it's not. We have an unelected branch providing pretty serious oversight, not just pretty serious oversight to other branches of governments that are elected. So that's kind of the primary issue here. Now, make sure that you spend some time reading the limited jurisdiction of the federal courts, because it's not like the federal courts can hear everything. They can only deal with things that are federal issues, right? So generally speaking, there's two types of cases. Any federal question that involves constitutional law or the judiciary interpreting or applying federal statutes to criminal and civil cases, like federal law, all right? And then questions involving citizens of different states too. So that's specifically what the Constitution allows the courts to do. Also, jurisdictional questions between federal and state courts, can be really complicated. So state courts have jurisdiction over federal civil claims unless Congress has given the federal courts exclusive jurisdiction in an area like bankruptcy. So it gets really intricate. Why does it get intricate? Because the Constitution is really short on instructions on how the federal judiciary is laid out. Who's the group or the branch of government that lays out the framework of what the federal judiciary looks like? It's Congress, right? And they have to be really specific, and especially in a federal system like ours, whose job is whose, right? So, what areas at the state level do we see the federal courts jumping in? When is it necessary? When is it not? And then also habeas corpus petitions. Those are petitions saying that somebody was not given their due process. Okay. Now, like I said, we've already kind of gone over this, and don't pay attention to this one right now, but the federal courts consist of three levels of the federal courts. There are 3 levels of the federal courts, 3 levels of the federal courts. The first is the U.S. Supreme Court, and it's just one court. The second level is the Circuit Court of Appeals. You'll hear this referred to as circuit courts or appellate courts. And then the third is U.S. District Courts. Now, this is separate, because we're in a federal system, from the state courts. So we have the state highest court, which is usually noted as the Supreme Court, and then we have the state appellate courts, pretty similar to the structure. I mean, there's a reason that the federal government is structured the way it is, and it's because there's a generally this is a good way to structure your court system. And then finally we have state trial courts. Like when you go to trial, or like when O.J. Simpson went to trial. That's a state trial court. Actually, that might have been... We'll come back to that. I'm quiet right now, not because the video stopped, but because I'm trying to think. All right, now, let me give you a few terms that you're going to want to remember. First, jurisdiction. This is the legal ability for a court to hear a case. What is jurisdiction, right? It's similar to, jurisdiction is the area of law that the court itself practices in. So if you see federal courts ruling on a case, their jurisdiction is going to be federal laws. Same goes for states. If a state court is looking at a case, it's dealing with state law. Now, it can get more specific, but the jurisdiction is the general area of law, and whether or not that court in particular, whether it be the U.S. Supreme Court, the Court of Appeals, U.S. District Court, is that within their purview to handle that kind of case? Finally, we have appellate jurisdiction. Appellate jurisdiction is not a trial court. It's called an appellate court. An appellate court comes from the term appeals. This court's job is not to put anybody on trial. It's to hear appeals reviewing decisions from lower courts, okay? So what they're looking at here in an appellate court is, how was the trial court's proceedings? Was anybody not given their due process? Was everything done properly? Was the law applied correctly? How was the law applied? Things like that. And so it's just a check on the judicial system, right, to make sure that people get their due process, which, if you remember, is a part of the Bill of Rights. Then we have precedent. Precedent is a legal norm that's established in court cases and then applied to other court cases, right? So in Roe v. Wade, you might remember, we heard that Roe v. Wade, that was the abortion case, established what we call the right to privacy. And remember when we talked about that, the right to privacy isn't specifically stated in the Constitution, and yet we see here that yet privacy keeps getting carried through, right? So we keep applying the right to privacy. It's because the right to privacy was established as a precedent. It's a legal norm that now other subsequent cases can use that establishment of the right to privacy to review other cases. And then finally, we have standing. Now, a standing is the ability for me or anybody, think about it in this way. Think about it. Okay, so let's say that I want to put a slip and slide in my neighbor's yard so that I can slip and slide on it, right? So I get the water hose and I put it in my neighbor's yard because they have a sloppier hill than I do. And then I slide down it. And then when I do, I fall into a bush and I scratch myself up really good. And then I decide that I'm going to sue them. Some people might say, do you have standing to sue them? Standing means, do you have a legitimate justification for bringing a suit against your neighbors? No, I wouldn't, right? And it's not just in civil cases like that. It's, is there something in the law that says you're even able to sue over something like that? And for me, it'd be no. Like there wouldn't be standing. There wouldn't be a legitimate reason to sue, a legitimate legal justification for me to sue my very nice neighbor. I keep pointing over there because they're just right out my window. Okay. Anyway, sorry. Federal court structure, as I mentioned, we have the highest court of the land, and its original jurisdiction is stated in the U.S. Constitution, Article 3, Section 2, the U.S. Supreme Court. The second level that we looked at the little triangle rung, right, is the appellate court. Now, before I get into the appellate courts, let me say this. Because Congress has allowed it, and because Congress is allowed to allow it, the Supreme Court, the highest court in the land, can hear cases appealed from lower courts, or they can hear cases that go directly to them only in certain instances. So let me say that again just to be clear. How does the Supreme Court get a case? Well, it could be a case that's appealed from a lower court. Maybe somebody thinks that the law wasn't properly applied in the lower federal courts. They could bring that up to the Supreme Court. Of course, the Supreme Court decides whether or not to hear it. The other way a case can get to the Supreme Court is through the original jurisdiction, the original area of laws that were laid out in the U.S. Constitution in Article Section 2. And you see that there. It's a weird face. Okay. The next level is the U.S. Court of Appeals. These are the intermediary courts because they're sandwiched between the district courts and the U.S. Supreme Court. There are only 13 courts of appeal, 167 judges, and most of them have 3-judge panels. So all of the judicial positions in the federal court, I have to scratch my nose, hold on. Okay, all the positions at the federal level are appointed. So we're going to see that Supreme Court, the appellate court, and then the district court. And remember that the U.S. Court of Appeals is an appellate court. They don't do trials. They just look and review at cases that other courts did. These are appellate courts, by the way. Okay, so the final rung in that, it's not really a rung, but the final level in that triangle was the federal U.S. district courts. 94 district courts, 590 active judges, all appointed by the Senate. That's who appoints them, and I have failed to mention that so far. Well, actually, no, the president appoints them, and yeah, the president appoints them, and then the Senate has to confirm them. It's a joint thing. So every state has at least one district court. The three largest states, like California, New York, Texas, they have 4. And these courts, the U.S. district courts, are actually trial courts. Remember, the appellate court hears appeals. The district court is about trials. And we're looking only in federal cases right now, okay? We're not looking at state-level cases. States have their own judiciaries. So in a federal case, it starts at the district court level. It goes to trial. It could be a civil case. It could be a criminal case, but it has to be about a criminal statute, a federal statute. It has to be about a federal statute for it to go to this court. And then the trial takes place in the U.S. District Court, and then if the party isn't satisfied with it, they can appeal the decision at the U.S. Appeals Court. If the U.S. Court appealed it, and they're still not happy, they can do another appeal to the U.S. Supreme Court. What we're looking at now are the current sitting Supreme Court justices. There are 9 Supreme Court justices. There didn't used to be 9, but there are 9 now. And we have here Justice Breyer. This is Justice Gorsuch, Sotomayor, the first Latina Supreme Court justice. Clarence Thomas, he's the one that I mentioned falls asleep because he thinks that by the time we get to the oral arguments in the Supreme Court level that already made up their minds. They've read all the briefings, everything. And in his career, I think he's asked 2 questions and he's been on the court for forever. Then we have, I always forget his name. Roberts. Yeah, obviously. He's the Chief Justice. And then we have Ruth Bader Ginsburg. She's the oldest. She's like 80-something years old. And she's got a wicked workout routine. She recently broke a hip, but like she does like minute-and-a-half planks kind of thing. She's wicked strong. Ironically, so judges, you know, they have ideology just like all of us do, right? So sometimes they lean to the left, lean to the right, conservative, liberal, that sort of thing. Well, RBG, Ruth Bader Ginsburg, is a very liberal judge. And the way her back is, she's always like leaning to the left. I don't know if that looks like, yeah, she leans to the left. So it's like, metaphorically and literally, she leans to the left. And then we have Sam Alito and 2 of these. So Gorsuch over here, Kavanaugh over here, 2 of the most recent ones, and then Elena Kagan, who actually has 0 experience being a judge. She was a constitutional law scholar. She was never a judge before she was put on the Supreme Court. So, and there's nothing that says that you have to be a judge. Yeah, moving on. Now, I mentioned that the federal caseload is pretty big, right? So tons of cases get filed at each level. SCOTUS receives 7,000, 8,000 cases per term. A term is a year. And I'm actually going to put on supplemental on your supplemental folder some links for these more recent counts of caseloads because these are from 2017. All right, now, let's talk a little bit more about the Supreme Court. How does the Supreme Court select a case? The most common way is through what we call writ of certiorari. This is a Latin term. Judicial terms are Latin terms. I know at least one of you is interested in going into law, and so, unfortunately, Latin terms make up this whole field of study, at any rate. So writ of certiorari. This is just simple. It's a request. It requests that the high court, when you see court with a C, capital C, that's the Supreme Court, orders a lower court to send records of the trial in question. Basically, writ of certiorari means you're asking the Supreme Court to look over the records of the case and make sure everything was done properly. Now, so this was done, so like I said, usually cases are sent to the Supreme Court by writ of certiorari. Now, once they get a case, how they choose is a lot more complicated, but in general, there is not a technical rule, but a norm that if four justices want to take on the case, then they take on the case. The procedures happen where first they get all kinds of information about it. They get briefs on what previous courts said, on the arguments. Both people that are bringing the cases, the appellee and the appellant, all of those are sending information to the justices for them to look at. Also, other people can send what we call amicus curiae, friend of the court. That's a brief that's sent to the Supreme Court saying, hey, I really think you should look at this case because of whatever reason. It could be because I think it's a really good case. It could be because this is my friend. It could be because injustice was really done. You can say whatever you want. As long as you fill the form out properly, anybody can give an amicus curiae brief. By the way, I'm going to call it amicus curiae because that's just how I call it, but that's technically not right. I'm just reminding you, if I slip into calling it amicus curiae, that's fine. Anyway, it's about an interested group sharing relevant information to the court that might help the court decide whether or not to take up the case, or whether or not to even hear the case. Now, once they decide to have a case and they've gotten all these briefs and everything, then they have oral arguments, and each oral argument, each person in the case, like there's the appellant and appellee, there's 1 hour for them to give an oral argument. No more nor less. And, oh gosh, actually, no, I said that incorrectly. It's 1 hour total for oral, so each one gets 30 minutes. But they may not even get 30 minutes because the justices may have tons and tons of questions, and it takes up all the time. So they may not even get to, so basically, if you have information as a lawyer or the appellant or the appellee, you want to put that stuff in the briefs, so the justices have a chance to read it. You don't want to save it for the oral arguments. Then finally, the justices meet in secret in what we call conference. In their conference meeting, nobody knows what happens. Literally nobody knows what happens. It's not recorded. There are no minutes. And only the justices are in it. And they discuss what the ruling's going to be. And then finally, they all write an opinion. Now, the opinion has several parts to it. One, it says, okay, here's what we decided about the case. Like, so we call that the holding. I'm trying to think about what's really pertinent for you guys. So they decide what the ruling is for the individual, like in the case. But because the case went to the Supreme Court, there are other big implications to it. Big implications that they want to set precedent or set legal doctrine on how lower courts should rule if they get a case like this later, right? Things like Roe v. Wade. Hey guys, there's a right to privacy in the U.S. Constitution. So anyway, the Chief Justice usually writes the majority opinion, or they can tell somebody else to write it too. Now, the final decision, like I mentioned, every Supreme Court decision contains two elements. And the first is the vote, who in favor of what party. That's what I described as the holding. And then the opinion part is where they justify it. The judges or the Supreme Court justices don't just say, hey, here's the ruling. Because they're the highest court in the land, because they set legal doctrine for lower courts at all levels of government, they can't just set the vote. They have to set the opinion, which is a justification of it. So this is a statement or a set of statements. It's usually rather long. I mean, like 10 pages. And the majority kind of explains the rationale. Why did we make this decision? Why did we determine that the Constitution has an implicit right to privacy, right? And that's the kind of thing they put in it. Precedent. The opinion includes precedent. That's a term we looked at earlier. Now, any justice can disagree with the majority, and they are allowed Nay, they are encouraged to include their dissents. And their dissent is not just, oh, I disagree. Their dissent is actually about them explaining why the decision they believe the court came to was incorrect. Now, sometimes Supreme Court justices agree with the vote, like they voted in favor of the party they wanted to vote in favor for, but they disagree in the rationale. In that case, those justices can submit a concurring opinion. The concurring opinion then helps them, well, it allows them to say, I agree with the overall result. What I don't agree with is the reasoning, and here's why, and here's the reasoning I think should be the precedent or the opinion or the legal doctrine that's set in place. All right, now, let's move on. Real briefly, in general, the Supreme Court, depending on who's the Supreme Court justice, depending on who's on the court, certain groups of justices are more inclined to take up certain kinds of questions. And it depends on kind of, what the nation, where the nation's at. So very early in the era of the court, there were a lot of questions about federalism, right? Because the Constitution was newly written, and there were questions about, all right, well, what's the jurisdiction or what's the role of the states versus the role of the federal government? And, of course we know that because of the Supremacy Clause, the federal government, the Constitution, that's the supreme law of the land. But a lot of cases in the beginning was about who is in charge. That says change. It's supposed to be charge. The state or the federal government. After that, we get kind of towards the New Deal era, and we start looking at government regulation of the economy. Those were the questions that the Supreme Court felt really needed a lot of answering. So what's the scope of authority extended to the federal government when it comes to commerce, when it comes to economy? The Commerce Clause again. I told you it would come up over and over again. And then civil rights and civil liberties has been most recent. So what's the relationship between federal government and individuals? And some of the more recent questions we've seen are the gay marriage decision, Obergefell v. Hodges. There's a recent decision that's going before the court that actually went before the court already. They've made a decision just this past term about whether or not transgender people are allowed a certain type of protection, that other minority groups are given. And basically, so anyway, these three areas are important because when we look, and it's not as just that the court only looked at federal decisions or federalism decisions. It's not as though that they only looked at regulation of the economy. It's just if you pull back, the scope is that in one era they look at this, in one era most of their questions are about this, in one era most of their questions are about civil rights and civil liberties. Remember, civil rights are those that derive from the 14th Amendment. Civil liberties are those that derive from the Bill of Rights. Anyway, these eras represent periods of very sharp disagreement between the court and elected branches. And oftentimes, when there's serious disagreement between the branches of government or between lower courts, we see this is when the Supreme Court decides it's time to step in and create some legal precedent, to create some legal doctrine. So I'm going to skip over the eras of the court and encourage you to, of course, read them. The nation versus state authority from 1790 to 1860, you see that first era. And then we talk about the second era where they're regulating the economy. Some of the cases you see here, Lochner v. New York, where the Supreme Court says that New York as a state cannot limit the working hours that people have. If they want to work 10 hours a day or 60 days a week, then people should be able to, things like that. And then we also have, the introduction of the New Deal. And then we have the third era, civil rights and civil liberties. And it's kind of still going on right now. So the court began to focus on rights and liberties in the 1940s, and it's still kind of taking place right now. Yeah, let's move on because we got to go quick. Now, to some people, there's a fourth era that, I know I just told you there are three eras, and you're right. I mean, I'm right. The book's right. There are three eras. But some people think that we're kind of like easing into a fourth era, and it's not really clear when you're going into a new era, you can't really identify it. Like, right away, which is why there's a question mark here. SCOTUS has been lately really asserting its position as a referee to keep political positions in their proper roles. And one of the questions that I'm thinking about right now was their decision with Bush v. Gore. Right, they had to insert themselves between a question that was, about an election process, not generally their area. Scratch my nose again. I know you're not supposed to touch your face, but I've washed my hands. Anyway. Now, when the Supreme Court issues a decision, what they want to look at is, or not what they want to look at, but what they're establishing is judicial doctrine. And when they write the opinion, they're creating judicial doctrine. It's the practice of prescribing in a decision a set of rules to guide future decisions on similar cases. Okay, and it's not just for SCOTUS to use over. SCOTUS is the highest court in the land, so they're telling lower courts, here's how you decide decisions like these. Okay, there's two types of judicial doctrine: procedural and substantive. Procedural doctrine governs specific ways in which the lower courts should do their work. Things like very specific stuff, like they have to follow the established precedent. There's a Latin term for that, stare decisis. Stare decisis, depends on how you ask. Then there's standing. So who can initiate, right? Is there a legitimate reason to bring this case? And then, there's things like you can't rule on something hypothetical. There has to actually be a case where somebody has been harmed, metaphorically or physically, in order for, it can't just be hypothetical. Substantive doctrine is a principle that guides judges on which party should prevail. Kind of like, all right, so notice here it says it's akin to policymaking. We think about it as policymaking because a judge who, in the absence of a clear violation of the Constitution or precedent, will defer from policies coming from elected branches. We think of that as judicial restraint. And then sometimes judges change doctrine to conform. Let me back up. Instead of reading the slides, let me tell you what this is. Substantive doctrine is how the Supreme Court looks at their role in making decisions that comes to them, right? Some judges think that their role is to let the elected branches do their thing, and they're supposed to step back and let the elected branches do their thing without interference unless the interference is absolutely positively necessary. And that kind of substantive doctrine is judicial restraint. Some justices see their role as being, as the title suggests, really active, that their role is about they have a very clear opinion about what the Constitution should mean, or what it's not supposed to mean, or what it is supposed to mean, and they want to do everything they can in their power, including affecting the decisions of elected branches. They want to do whatever is in their power to make the decisions that the Supreme Court has conform to what his or her idea is. Now, typically, conservative judges practice judicial restraint. Typically, liberal judges practice judicial activism. But that's not always the case. Sometimes we have conservative justices that are trying to interpret the Constitution in a way that kind of gets their ideology across. And the same goes for judicial restraint, too. For example, there are some liberal justices that believe that if you look at the First Amendment, that we have the right to free speech. Some justices have asserted over and over again that that is unequivocal. Everybody has the freedom of speech. There is under no circumstance that the government could ever restrain speech. But technically things like child porn, right? That's an expression, right? And the court has determined over and over again that that's not something that is protected by free speech. I'm not saying liberal justices are in favor of child porn. What I'm saying is that judicial restraint and judicial activism is not assigned to whether or not you're a liberal or conservative justice. I think you get the picture. All right, so a few things about the Supreme Court. Does the Supreme Court have the last word on policy? Meaning, if congressional law goes before the court and the court decides it, do they have the last word? Well, judicial review seems to give the court the last word on public policy. I mean, they said, hey guys meaning the congressional branch, they said, hey Congress, the Judiciary Act of 1789 is unconstitutional. And they've done that before. It's not just, that was just the first time they did it. So is that the last word then? Is that it? Whatever the court says goes? Nobody can do anything back? Well, think about what the Supreme Court can actually do to make people follow their rules. Think about Brown v. Board of Education. If the executive branch hadn't been on the court's side to establish that segregation was equal treatment, right? I don't know if I said that right. So the Supreme Court ruled segregation not okay. If the executive branch didn't agree with that, the courts would have had a really hard time seeing that through. Why? Because the courts don't have any judicial enforcement. There's no Supreme Court army, right? So they told the states, you've got to desegregate, and many of the states just ignored them. Think about Arkansas. They ignored the ruling until literally the executive had to send in the National Guard, the military. So there's an absence of judicial enforcement. And so there's evidence that the judiciary is actually relatively weak, that their very legitimacy comes from the idea that we have to think they're legitimate in order for them to be legitimate. Also, there are subtle ways that Congress and the president can redirect judicial doctrine. For example, sometimes the Supreme Court will make a decision and say, hey, Congress, this congressional statute, this legislation is not constitutional, so Congress can then rewrite it with the direction given by the judiciary, the Supreme Court. The Department of Justice actually helps. That's part of the executive cabinet. It's a department that helps the Supreme Court kind of keep an eye on what issues are coming up. And then judicial recruitment, right? So the president nominates justices, the Senate. Yeah, I'm still recording. Okay, sorry. The Senate also has to ratify those or confirm the nominations. And to change the makeup of the court, all anyone has to do, or all the president has to do, is just put in a bunch of conservative members or a bunch of liberal members. That's what happened when FDR was trying to get the New Deal passed. The Supreme Court was given a lot of trouble. His idea was to ask Congress to pass legislation that increased the amount of justices on the Supreme Court from forget what it was. I want to say it was 4 or 3 more additional justices and on the Supreme Court, because there's no set number of how many justices there can be. So FDR figured, well, let's just add some more members, and I'll make sure that I pack the court with a bunch of, progressive justices, and then I can get my, the New Deal passed. Pretty clever. Didn't work. We only have 9 justices right now. All right, that's it. The rest of the slides were going into a little more detail about, that big question, does SCOTUS have the last word? Anyway, I hope this was helpful for you. It wasn't quite a full class period, 40 minutes, and it was kind of an expedited version. Usually I like to spend at least 2 class periods talking about the judiciary, but hopefully this helps.